Good morning. Today we're going to be talking about Chapter 5. And since I'm going to be gone for the next 3-4 days, I wanted to go ahead and make sure we stayed on track. And so we are going to look at the court system and how it's described in Chapter 5. Now, I'm going to move through this pretty quickly. Follow along in the notes, fill in as necessary. Obviously, stop the recording when you need to, and then move forward as you need to. So, let's begin. Court system. Court system is not exactly the same in every court in the United States, but the general idea will always be the same. So what I'm going to be talking to you about is this general idea of how the system works in most of the U.S. There are some differences from state to state, county to county, but I will address some of what you might see here in Preble County, so and in Ohio. So let's get started. Okay. So our targets are these, and please add these to your notes. Students will understand the basics of the U.S. court system. They will understand how the Sixth and Seventh Amendment protects and guarantees the rights of the accused, the steps taken in a civil and a criminal trial, how a case can be appealed, the makeup of an appeals court, and then the two separate court systems in the U.S., which are the state and the federal. All right, so we're going to start off by first looking at the Sixth and Seventh Amendment. If you remember from government class, we talked about this when we were looking at the Bill of Rights. In fact, my government class, that's what we're working on right now, are the Sixth and Seventh Amendments. So let's look specifically. Sixth Amendment guarantees the right to trial by jury in criminal cases, and this applies in both state and federal cases. Originally, when the Bill of Rights was written, it only talked about for federal, but as time has passed, it applies both to state and federal cases. Seventh Amendment guarantees the right to trial by jury, and not only that, but in civil cases. So we're looking directly at the issue of juries and their importance. Okay, so juries are not always required or needed. In civil case, either party may request a jury. In the criminal case, the defendant decides whether there will be a jury. So if you remember, civil cases are all about issues between individuals or groups. In a criminal case, it's the government against a particular person or persons, the defendants, and the defendant gets to decide whether a jury will be needed or not. If they choose not to have a jury, then the judge makes the decision. So here is kind of a breakdown here. We're talking about first the lowest level in the court system, which is the trial courts. Now, when I call it lowest, it doesn't mean it's unimportant. It's just the first step, if you will. And as such, it plays a big role in this total package of the court system. So the trial system in the U.S. is called an adversarial system, which means it's basically a contest between opposing sides or adversaries. Criminal case, it's between the government and the defendant. Civil case, it's between two either individuals or groups, but the government is not a part of that. A trial can either be, as we've said already, a non-jury trial or a jury trial. If it's a non-jury trial, the judge presides over the trial, meaning he's kind of the watchdog. He's checking it out, making sure all of the issues are being dealt with. In addition, he determines the facts of the case and then decides. Basically, he's looking at what both sides have presented and then decides. whether and then presents a sentence to possibly whoever is guilty. Now, a jury trial, again, the judge presides over the trial. He's kind of the referee, if you will, and that's true for both sides, whether it's a non-jury or a jury. He protects the rights of those involved. And that's in an effort to make sure that the defendant is not, or the plaintiff, either or, is not being run over by the other sides, that the law is being protected. Okay, he instructs the jury, she instructs the jury as to the law, and then will possibly sentence those convicted of a crime. Okay, so that's the general idea. All right, so trial courts, as we said, is an adversarial system, and this is a theory that the trier of fact, the judge or the jury, they're the decision maker, will be able to determine the truth if the opposing parties present their best arguments and show the weaknesses of the other side. So what I tried to show you here is, here's the judge, he's presiding over the jury, or over the trial, sorry, and you've got the plaintiff in a civil or the prosecutor in the criminal trial, and then you have the defendant. And these two will present their cases, defendant through their attorney, plaintiff through their attorney, prosecutor who is the attorney, back and forth. The jury the whole time is watching this and listening to both sides. So they are back and forth with each other, and then the jury, but they're also presenting to the jury in an effort for them to decide which one they think is the truth. Okay. Now, if there was no jury, it would be the judge. So you could just you could change these to appear to the judge if you wanted to. But in most cases, there are jury trials. All right. So let's define a little bit who these people are that are in the court. First of all, we're looking at the prosecuting attorney, who is a lawyer, usually who works for the government and tries criminal cases. It's his job, her job, to initiate or carry out legal proceedings against a person who has been accused of a crime. So they are the one, they actually decide, often they decide what the actual charges will be. They will look at what the police have identified, what the police have pulled together in the evidence, and then they make the final decision as to what charges will be set against an individual or people or a group of people. So on behalf of his national, regional, or local court system, he works to convict criminals or secure other forms of justice. Other forms of justice could be restitution or some sort of settlement that will then address whatever crime has been committed. The defense attorney then typically has the job of working on behalf of an accused criminal, helping them to avoid conviction or at least seek a lesser penalty. I think I ought to do this real quick, / her, and do the same here with her. Okay. There we go. Okay. There you go. All right. Let's move forward. All right. Going on. So a jury trial, a jury is selected and charged with the task of determining the facts and applying the law in a particular case. They don't have to guess at the law. The judge provides them with the information needed toward deciding on what the law is in this case. Now, the requirements to serve on a jury: you have to be a U.S. citizen, you have to be at least 18 years old, able to speak and understand English. You do not have to write, but you do have to be able to speak and understand English, and you must be a resident of the state in which you are, the trial is occurring. In order to be chosen, there is a process, and it's known as voir dire. or it can be pronounced Fwadire. I've heard it said so many different ways, but those are the two most often said. So what happens is this: you are notified by mail. Usually you get a little postcard, and it says, "Congratulations, you have been selected for jury duty." Will be. If called, you then arrive at the courthouse to wait if the trial proceeds. There is a chance you will have to do nothing. You may literally spend possibly a day there with nothing to do, because you are now part of a jury pool. You get a questionnaire as provided, and you will fill it out. And if the trial proceeds, then you are sent to the courtroom. The first 12 people are seated, then the prosecutor or plaintiff question those seated. The defendant also gets to do this. Let me add that. I didn't realize I didn't add that. The defendant's attorney will also question those who are seated, and their purpose is to discover any prejudice or preconceived opinions concerning the case. There we go. So it is a simple process, yet it can be very time-consuming, and but it's something that is, again, it's part of your civic duty. It's something that, as a citizen of the United States, you should be willing to be a part of this. It may not be the most interesting thing in the world, or it could be one of a fascinating thing. Depends on the case. You never know. But it is part of your civic responsibility. Now, you can be excused from duty if you can show undue hardship or extreme inconvenience, but that's hard to do. So you can be exempt from jury service, but there's no guarantee. Clergy, attorneys, physicians, police officers, firefighters, and persons unable to undertake jury tasks because of mental and physical disabilities, they can be exempt. But it's not like you can raise your hand and say, excuse me, I can't do it because I'm busy that day. Judge will not be interested. In fact, don't do it. It's a bad thing to do. But you can, if you can show particular issue that would be of concern. Like, for example, if you are the sole caretaker for a family member, and without you, no one else is there to be able to help, then you could possibly, and I'm not guaranteeing that, you could possibly use that as a reason to be exempt from jury duty. Now, you can also be removed for cause. This would be a reason that the attorneys, when they question you, can determine. Any juror may be removed who appears incapable of running a fair and impartial verdict. For example, if you're related to the defendant, you're probably going to get removed for cause because you will most likely be biased towards that defendant. That's just one example. Now, a peremptory challenge, prospective jurors can be removed without stating a cause. Generally, the attorneys only have that option for 2 individuals, although that's not limited. It depending on, again, where you are as to what number of people you can be removed for peremptory challenge. As you can see, removal of cause can be unlimited, again, because of reasons, you want, it's supposed to be a fair and impartial jury, and you can't get a fair and impartial verdict unless that jury is fair and impartial. Okay, so let's move on. Let's look at steps in a trial. Now, if you remember from government, we talked about something called due process. A due process is that everybody gets the same type of trial. And what we're looking at right now are the steps in the trial, and these steps are the same whether you are rich or poor, civil case or criminal case. The steps in the trial remain the same. There are some variances depending on some circumstances, but the general idea will always be the same. You begin first by an opening statement, either by the plaintiff or prosecutor. plaintiff's attorney or the prosecutor explains to the trier of fact, again, the judge or the jury, the evidence to be presented as proof of the allegations. Okay. And the allegations written in papers filed with the court. Basically, we're talking about the reasons you are there, whoever or the person, the defendant is there. Okay, then the second, opening statement by defense. So what you're going to see in several of these steps are their mirror effects. One side gets the opportunity, opening statement, and then the other side gets the opportunity to basically do the same thing. The defendant's attorney explains evidence to be presented and to disprove the allegations made by the prosecutor. So their job is to say they don't know what they're talking about, they know what they're talking about, and vice versa. They want to say these guys don't know what they're talking about, but they know what they're talking about. Okay, moving on. Then, third step is direct examination by plaintiff or prosecutor. And this is the opportunity for the plaintiff prosecutor to question their witnesses. Other evidence, such as documents and physical evidence in favor of the plaintiff or prosecution, is presented. Step 4. Then you have the cross-examination by the defense. Again, it's the mirror of this. They are presenting evidence. Now it's their opportunity then to break down or discredit the evidence or the witness. So the defense has the opportunity to question each witness. That is fundamental, that they have the opportunity to question. And then, of course, again, the question is designed to break down the story or discredit the witness. Then 5 is kind of the, if you want, halftime. This is an opportunity for the prosecutor and the plaintiff to tell or go to the judge and say, look, they have not presented enough evidence. The evidence they have produced is useless, and really the trial doesn't need to go forward any further. And it's the judge's job then to decide whether that's true or not. And so they, the prosecution will make this motion. The judge then will decide, and oftentimes it is a simple decision. And in saying that, yes, we're going to move forward. It takes a lot for a judge to say, we'll stop the case right here, but it does happen periodically. So, and it's, but it is an important part, and in any trial, a judge, or I'm sorry, a prosecutor or the plaintiff or the defendant can, well, actually, it's the defendant who makes the motion. The defendant can say the prosecutor or the plaintiff hasn't done their job, let's stop. Judge can make that decision. Okay, 6. Direct examination by the defense. Okay, so now it's the defense's turn. They're going first. They're presenting their witnesses to be questioned, evidence to be presented, and they will then, in an effort to show that their client is in fact innocent. Now we have come to the cross-examination of the plaintiff prosecutor. They're going to examine any of the witnesses presented by the defense, and they are in an effort to prove, again, that the defendant, in fact, is guilty. Okay, remember, this is an adversarial system. Now, finally, then we have, once that's all said and done, then we do the closing arguments or the closing statements by the plaintiff or the prosecutor. Prosecutor or plaintiff review all the evidence presented, noting uncontradicted facts, and ask for a finding of guilty or a finding for the plaintiff. This can be a very long, drawn-out process because they can go over every single thing again. Closing statements, you see on TV, they take less than a minute or two. And this is not true necessarily at all. It can be a very time-consuming process. Then once the plaintiff or prosecutor is done, then the closing statement by the defense. They have an opportunity then to present Their side, once again, they are, of course, asking for a non-guilty verdict for their defendant. Okay. Now comes the rebuttal argument, which you never quite see, again, on TV. The prosecutor has one more shot at explaining the evidence again. They can bring in additional points or refute the information that the defense attorney has brought forward, and then that part of the trial is over. The defense or the attorneys are basically done at that point. Now it goes to the jury. The jury is sitting there, and the judge then instructs the jury as to the law that applies to the case. They go, the judge is very specific on what laws are identified as having been either broken or apply to the case in some way or another, and then they tell the jury, go and make your decision. There are not many instructions for the jury. The jury really has to kind of work out the process on how they make the decision. And my hope is that we will be seeing a video on this when I get back. And it kind of shows how the process works out. All right, finally, 12. When the jury has finally come to their decision, they come back to the court and they present their verdict. In most states, a unanimous decision is required for a verdict. If the jury cannot reach a unanimous decision, it is a hung jury, and the case must be tried or can be tried again. That's up to the prosecutor whether that'll happen or not. If it is a civil trial, it doesn't always have to be a unanimous decision, but in a criminal trial, it usually always does. All right. Now, if the trial ends in a guilty verdict, the defendant, and this is, I'm referring to a criminal situation, the defendant has the option of possibly an appeal. But appeal just can't happen because you don't like the verdict. Appeal can't happen just because you think that it was unfair that you were found guilty. Appeal can happen only if there are 3 reasons. First, the verdict was unreasonable or couldn't be supported by evidence. For example, if you were found guilty of, let's say, some sort of drug crime, and you are relatively, it's not a relatively serious situation. It wasn't a major, not a drug dealer. You were just maybe found with drugs, but they ended up giving you 20 years. That's an unreasonable verdict. So that could be appealed. Also, number 2, the judge could have made an error of law. And that would be if they misinterpreted something incorrectly, if they identify a wrong law to be dealt with in the jury selection or in the jury process. There could be a lot of different ways error of law can occur, or there's a miscarriage of justice on any grounds. So, for example, if you were found guilty simply because of the color of your skin, that would certainly be a miscarriage of justice. All right. So, if it's possible for you to have an appeal, again, this idea of an error of law is a mistake as to the law that applies to the case. If it's a minor problem, the trial court decision will probably not be reversed. And what we're talking about is if the error did not make any significant difference into whether this person would have been found guilty or not, then most likely the appeals court will not overturn or reverse the decision. The decision will stand. Okay. Now, it's also part of court decisions are something known as precedent. When an appeals court decides a case, a written opinion is issued. This opinion sets a precedent for similar cases in the future. What they're saying is lower courts in the area where the decision will be will follow a precedent in similar cases. A higher court has a power to reverse or change a precedent, but in most cases, they will follow along with what has already been decided. This is a way to keep the application of the law equal or similar. Okay, it's being consistent. Okay. Courts in other parts of the country are not required to follow precedent, but they can and often do. So an appeals court is where one party presents an argument asking a court to review the decision of a trial court. The other party presents arguments supporting the decision of the trial court. Important to remember, in an appeals court, it doesn't look the same as a trial court. There are no juries or witnesses, and no new evidence is presented. Only lawyers appear before the judges to make legal arguments. Once an appeals court makes a decision, they will issue an opinion. Now, let me go back for just a second. One thing I did not mention here is that what happens in this appeals situation is the lawyers appear with the judges and make their legal arguments. And at that point, judges will question the attorneys. They will question them about the trial. They will question them about the evidence. They will question them about the problem, whatever has brought them to the court for an appeal. So it's their job to look at whether this case actually deserves to be overturned. Okay, now moving on. Once they make their decision, then they issue what's known as an opinion or a written opinion. And the majority opinion is basically the decision of the court. It decides, and in many cases, a majority opinion is unanimous, although it doesn't have to be. Unlike in a trial case with a jury, things have to be unanimous. It's not true for the appeals court. If you have 3 judges, then the majority opinion would be 2 out of the 3. If you have 9 judges, then obviously the majority would be 5 out of 4. But again, it can be any number. And this is the decision of the court. Then in addition, if a judge wishes to, and they disagree with the majority opinion, they can write what's known as a dissenting opinion, meaning reasons why they disagree with the majority opinion. That often happens, especially important when you're looking at the Supreme Court. The dissenting opinions are extremely important to look at because they often present very valid arguments as to why the majority might be correct, or incorrect, I should say. Then we have also one additional type, and this is known as concurring. A concurring decision or opinion is that they agree with the majority opinion, but for different reasons. They may write a concurring opinion saying, yes, I do agree, but here's the reasons why I agree with the decision. Not necessarily the same as the majority decision. Okay, so let's look at Ohio state and federal court structure. Okay, we will have a graphic organizer when I come back, but we're not going to look at that. All right, so the court system is this. State courts have broad jurisdiction, hearing cases that deal with state law as well as many areas of full federal law. Okay, then we have federal courts, and they have limited jurisdiction, hearing cases, criminal and civil cases involving federal law. And then we have federal trial courts, and they are known as U.S. district courts. Now, oh, never mind. We're not going to do that. Sorry. Oh, yes. Wait a minute. Yes, we are. Sorry about that. My hope is that we will be going to federal district court, which is in Dayton. We're working on a field trip right now, but we're not getting our people to contact us. So hopefully we're not going to miss out on that. So, but it's a great field trip. We're going to go and see how a federal court actually works. So we're looking at federal issues involving federal law. State courts are those courts that can be local, but state courts can also include a state Supreme Court and state district courts or appeals courts. So Ohio, let's look at this. Most states' courts resemble federal courts in structure and procedure. All states have trial courts. Now, here we go. State courts have broad jurisdiction. What we're looking at here are the courts, our local courts here in Preble County. Right? These are known as, first one is known as common pleas. That is the overarching court. It kind of is responsible for all the other courts, but specifically they are responsible for family issues, domestic relations, criminal, civil, bankruptcy, divorce, and so on. Now, juvenile courts, some of you know juvenile court. Juvenile is responsible for traffic, juvenile traffic, delinquency, dependent and neglected children, child abuse, child support, and truancy, among other things. These are the lists I'm providing you with here are not exhaustive. There might be additional things that would be a part of each of these trials, but these are the primary things that I'm noting. Probate. Probate includes wills, administration of estates, guardianships, marriage license, adoption, determining competency, eminent domain, and marriage officiants. Okay, meaning you can get married there. Okay, municipal court, then this is the fourth court. Criminal, misdemeanors, preliminary hearings, and felony cases determine probable cause, small claims, and adult traffic. This preliminary hearing in felony cases determine probable cause is significant. This is where you begin if you have a felony charges, and this is where it will be decided if in fact you should be held over for trial. Okay, so trial courts in the majority of all the cases, these decisions are usually final. The trial courts are these guys right here, right? Mostly this one right here. This is trial court, common pleas court. Okay. So, sorry, went backwards. There we go. Trial courts, here are the majority of all cases. These decisions are usually final. However, if you lose a case in the trial court, and if there is an error, you may appeal. This is a bit of information. Overall, the federal courts handle about 1 million cases per year, and the state courts handle about 30 million cases per year. About 1,700 federal judges and about 30,000 state court judges decide these cases. So this gives you an idea of the difference between the federal and state. State, I don't want you to assume that the state courts aren't that important. In fact, quite the opposite. They, as it said, handle a majority of all the court cases. All right, so here's an example of an appeals court, what it looks like. This is not from Ohio. This is just a picture that I found. These are the 7 justices of a Supreme Court somewhere in the United States. Don't know where. Okay. But this one is a picture. I couldn't get a picture of one with the judges, but I want you to see our Supreme Court is magnificent. I've been there and watched a few trials, and it's pretty amazing. You can see that the architecture alone is pretty. Okay, all right, let's move on. So here are the Ohio justices. Our Chief Justice is Maureen O'Connor, and then we have Justice Terrence O'Connor, and they are not related. Justice Sharon Kennedy, Judith French, Patrick Fisher, Patrick DeWine, and Mary DeGennaro. Sorry. Okay, those are that's the Ohio Supreme Court. Okay. I think what I'm going to do is I'm going to stop right there, and we'll continue on. Now, remember, once you have finished this, you need to upload it to Moodle, and then I will grade it from there. This should be done today. do not fool around and not get this work done. So, all right, we'll see you soon.